One of the most common questions that I get from a new client basically is, okay, I've been in a wreck or I've had this loss. This has happened to me. Um, I understand who's at fault and who caused my loss. Um, and so who is my case against? Am I going against an insurance company, or is my case against the person that hit me? Basically, who are the parties here? And that's really important to understand that in Missouri, someone who's been injured, who's been in an accident, uh, they very often do not have a right to bring a direct claim against an insurance company. And so if you've been in a wreck and there's someone else that's hit you, your claim is against the person that hit you. But that person's insurance, and then perhaps other companies, maybe underinsured motorist carriers, something like that, umbrella carriers, they will end up paying the result of that case against that other party. And that's important to keep in mind, because there's lots of rules of evidence and procedural rules that apply in that situation. Now, a first party case, maybe this is a case where the person that hit you doesn't have insurance and you have to go after your own. Maybe your house burned down and you're going after your own insurance. Those are cases that can be filed directly against an insurance company. And trust me, the companies know who your case can be against, who it can't be against. And that's why it's very important to understand from the outset who the defendants are, who the parties are that are going to be paying the judgment or the verdict. Because if you don't understand that, you don't understand how insurance coverage applies to your loss, then there's a chance that you get started off on the wrong foot from the very beginning. And later on, you may end up in a situation where you've got a result against someone, but no one has to pay that result. That's what we don't want. That's why it's important to get all the information, to get all your ducks in a row, form a good plan, and execute on that plan.